Any mention?
May it please your Lordship. Lordship, I beg to make a mention of item 2 from the daily list. Lordship.
Yes.
Lordship, I'm praying if this matter may be listed after a week's time. No objection, your Lordship.
It's 2014 matter, item 2. True, no?
Yes, sir.
What is this matter about?
Lordship, this is regarding the capital subsidy under
Regarding
the...
subsidy, Malad. So main contesting parties are the Union of India and the British.
State is also a party.
State is a party, Malad.
What is their allegation in the case?
Malad, basic allegation is that some subsidy.
They have not been provided with this subsidy. Is this
Lordship.
No objection.
No, your Lordship.
Honored Counsel for the petitioners. Please for grant of adjournment of the matter by when?
2 weeks, Lordship.
By 2 weeks. Honored Counsel for the respondents have no objection. Prayer allowed. List of it.
Highly obliged.
Malad, I beg to make a mention of item 5, Malad. Kindly grants me a week's time, Malad.
What is this matter?
Malad, this is regarding seniority, Malad.
No objection. This is promotion, seniority, something.
Yes, seniority, Malad.
This is also 2018 matter.
Malad. I'm praying for a week's time, Malad. Next week we'll take up.
After a week? Yes. As provided by the London government advocate, this is matter after 1 week. Yes.
Obliged.
Lordship, I beg to mention item number 4, Lordship.
Yes.
I'm praying for 2 weeks' time, Lordship, in this matter.
No
What is
objection.
this matter? These are all old matters.
Yes,
This
Lordship.
is the
Service
fundamental
matter.
proceeding, yes.
Old matters, you should do it fast. Why you are keeping it pending?
Lordship,
What benefit do you get by keeping it pending?
due to some personal difficulties, after 2 weeks, Lordship.
From 2018 till now, you have personal difficulties.
Lordship.
Yes.
No objection. Madam.
This also petitioner prays for grant of time. Comma. The respondents has no objection. Prayer allowed. List of 2 weeks. Yes.
Lordship. Similar prayer for item number 14, Lordship. Here
Yes.
also I'm praying for 2 weeks' time, Lordship.
Lordship, in fact, this matter has been disposed of by the Learned Sessions Court
Okay. What is the matter about?
under 354. The conviction is under
exactly.
354.
No. What is the challenge here in this matter?
For quashing of the FIR,
Quashing
Lordship.
of the FIR.
But then judgment has already been rendered.
Judgment in the month of July. I have a copy of the judgment, Lordship.
Then what happened in the judgment? What is the
The Learned Sessions Court upheld the conviction of the Court of CJR.
upheld? It means there was a conviction by the
The Court of the Chief Judicial Magistrate.
okay. So it
Appeal was filed.
challenged-
Appeal
challenged
was
or not?
filed.
Why? What for this criminal petition came in between? What is the prayer in this criminal petition?
For this for setting aside this FIR. This FIR dated.
Oh,
to-
for quashing of the proceeding.
Quashing of FIR.
But the time when this criminal petition was filed, there was already a conviction order,
By the
trial court.
By
Was
the
it something like that?
yes, sir.
Because this is a recent case. No, this is something that there is no mention about that in this petition. Is there any mention about this thing, the conviction of the petitioner?
Because
by the trial
the
court in this petition.
the judgment by the Chief Judicial Magistrate was passed on 21st July 2023.
So this must be then. So in this criminal petition, is there any mention of that?
No, Lordship.
There's no mention.
My God, you have suppressed all those things. You'll have to pay for it if you do this.
Lordship, after 2 weeks, my senior, due to some
This is
personal
something
difficulty-
very dangerous.
Because in
He
this
has participated in the trial.
in this
isn't it?
criminal petition, it was mentioned that
But
the
then
matter
you
is
also did
pending.
not bring it to the knowledge of the court before that there already exists one order of conviction against him.
That was brought to the knowledge of the Honorable Court, Lordship, by my
Is it-
lenient learned senior.
Is it recorded somewhere? We have to see.
Because it's not recorded.
When you see it, will
Let it come after 2 weeks, Lordship.
why after 2 weeks? If it is the thing, then it should go. It will come up next week. If that be the thing, what Mr. Highness submitted, if it is correct, then you'll be in problem.
And we are yet to receive the copy of the judgment here, Lordship.
No. See, if there was a conviction order standing against you at the time when you filed this criminal petition, why there was no disclosure of that in your petition?
I have no instruction in this matter, Lordship.
You cannot avoid by saying it when there is no instruction. If you have no instruction, see, this petitioner will be in trouble. What is the sentence? What is the sentence there?
1 year. For 1 year, Lordship.
1 year.
Okay, we'll give them time and then we'll just see on the next day. Please place it before on the next day.
Yes, Lordship.
Learned counsel for the petitioner. Praise for them. Praise for grant of some time. On the ground that some fresh instruction is required to be taken in the matter. The prayer has not been objected to by the learned counsel for the respondent. Accordingly, list this matter after 2 weeks.
2 weeks.
Make sure, see, madam, take care of all those things. If this is the thing, then you'll be in problem. Yes.
Obliged.
All right.
May it please Lordship. Lordship, I beg to mention item 12. Item 12. Yes, Lordship. Lordship, I pray that this matter may be taken up
Yes.
after 2 weeks, Lordship. The conducting senior counsel, it's in
I have an
sanction.
objection, Your Lordship. Lordship, due to this pendency of this instant matter, Your Lordship, the learned child court or Dhubri, Lordship, they are not passing maintenance order, Lordship. So I'm suffering, Your Lordship. So moreover, I have to maintain my 5 months child also, Your Lordship.
What this petition has to do with the passing of maintenance?
Your Lordship,
This
the
is seeking
conducting,
quashing of,
yes, Lordship, the conducting counsel or the counsel for the petitioner on Your Lordship, they inform the learned child court at Dhubri, Lordship.
Can that be there? This cannot be. Yes.
Your Lordship, as per my instruction, Lordship, that this is only for
No,
quashing
but
the
what
FIR.
about that you say like that she cannot even go ahead with her claim of maintenance because of the pendency of that?
About that, Your Lordship, I don't have any instruction, Your Lordship. Lordship, that this matter may be taken up after 2 weeks then.
Okay, Mr. You are Mr. Slong.
No,
Lalu.
Ilalu, yes.
Lalu. You are Mr. Lalu, learned counsel for the petitioner. Praise for. Adjournment on the ground of the matter. Adjournment of the matter on the ground of non-availability. Praise for adjournment of the matter by 2 weeks on the ground of non-availability of the senior counsel. Appearing for the petitioner. The prayer has been opposed by the learned counsel for the petitioner. The learned counsel for the
Respondent number 2, Lordship.
on the ground that pendency of this matter is causing hindrance to the respondent number so and so to advance her claim of maintenance, to pursue her claim before of maintenance before the appropriate forum. Have you filed an application?
Yes, Lordship, before the trial court, Dhubri, Lordship.
Give a reason. In view of the above, comma. In view of the submissions, comma, legal commissions, the prayer for adjournment of the matter by 2 weeks granted. However, it is made clear the pendency of this matter shall not be cited as a ground to deny the claim of the respondent number so and so of maintenance. Stop. Next paragraph, list accordingly.
Lordship.
Now this will clarify your thing.
Yes, Lordship.
At least if that contention is raised, you can.
Yes, Lordship. Obliged, Lordship.
May it please your Lordship, I beg to mention item number 11, your Lordship. The conducting council is facing personal problems, your Lordship.
Who is the other side?
I'm there, man.
Any objection?
No, no, no.
Yes. Just say 2011, an accommodation has been sought on the ground of non-availability of the conducting counsel for the petitioners. Stop. The learned GA has no objection. The matter, give a full stop. So now the matter stands adjourned to 2 weeks. Just record their appearance.
Obliged, your Lordship.
May I please your Lordship? Lordship, I beg to mention item number 9. Lordship, kindly allow 4 weeks of time.
Item 9.
Yes, your Lordship.
Yes.
No.
This is as requested by the petitioner. This is matter after
4 weeks, Your Honor. 4 weeks.
why 4 weeks?
Since this similar kind of matter is pending before DP, Your Lordship.
Okay. 4 weeks. Huh? Just make it 4 weeks. Yes.
Highly obliged.
May I please your Lordship, I beg to mention item number 6.
Yes.
Your Lordship, it is a joint request from both the parties. It is a joint request from both the parties
Yes.
for the adjournment, my lord.
When do you want it?
Your Lordship, after 4 weeks, Your Lordship. After 4 weeks.
Why 4 weeks?
Lordship, that was
You
instruction.
are the petitioner.
Yes, Your Lordship.
Say on the joint request of the parties. This is matter after 4 weeks. You are out of service.
Yes, Your Lordship.
But even then you want 4 weeks. Okay.
Your Lordship, I'm praying for a similar in item number 7.
Who is there in item 7 on the other side? It is not a joint prayer.
No, my
Your Lordship.
This is one. When do you want it?
This also, Your Lordship, after 4 weeks, Your Lordship.
Why all matters are for 4 weeks?
2 weeks. 2 weeks.
2 weeks,
Your
my lord.
Lordship.
What is the matter about?
My lord, it's a quashing only, my lord. Quashing.
Quashing of what case?
354. 354, Your Lordship. Gender bias. Regarding gender bias.
The
Gender
interpret.
bias.
Gender neutral.
Yes.
There
What is the offence alleged in this matter?
My lord, 305.
354, Your Lordship.
354, my lord.
354, Your Lordship.
354, my lord. So,
Compoundable, not compoundable.
no, no, no.
Yes. This also say on the request made on behalf of the petitioner. This is matter after 3 weeks. Yes.
Reply.
For Your Lordship.
May it please your Lordship, I beg to mention item number 8. Number 8.
Yes.
I pray for 2 weeks' time, Your Lordship.
Yes. What is the status of the case?
Status of the case, because on the last occasion the investigation was pending and they have not filed an FR.
This is the same case, isn't it?
Same
The
case,
FR
yes,
was filed, but then it
was-
was objected to.
Yeah, objected in reinvestigating the
Then
matter. Yes.
reinvestigation.
Yes, Your Lordship.
Now you are reinvestigating, but then nothing has come till now.
As of now, I also have
When do you think that this investigation will be completed?
I have not taken the
You
latest
just
status report.
cannot keep the thing open. You see, like this. If you say that you will be investigating the matter, it is your agency which submitted on FR.
Yes, sir. I'll take the latest status report of the
Please
investigation.
tell the investigating authority to complete the investigation. This is not something that they have to travel outside to find evidence and all those things. Something has happened within certain area.
Yes, sir. So
It should
anyway,
be completed fast.
I'll take the latest status of the investigation, Your Lordship.
Okay. This also just say as requested by the, as prayed for by the petitioner, this matter after 2 weeks.
2 weeks.
2 weeks. Yes, sir.
I'll
Much
update you.
polite. May it please Your Lordship.
Yes.
Lordship, I beg to make a mention of item number 10, Your Lordship. On behalf of P. Nongbre, Your Lordship. I pray if this matter may be listed after 2 weeks, Your Lordship.
No objection, Your Lordship.
This is also quashing.
Lordship, this is an application filed under section 482, Your Lordship,
Quashing, Your Lordship.
for quashing of the impugn orders, Your Lordship.
Orders by the court. There is also orders concerning what?
Rejection of prayer to summon a witness, Your Lordship.
311.
Yes, Your
Rejection
Lordship.
under 311. Of which prosecution witness or defense witness? Oh no, it should be defense witness.
Defense
isn't it?
witness, Your Lordship, yes.
What is the status of the trial then?
Your Lordship will have to seek instructions regarding
Is there
the
any
status.
interim order passed in this matter? No. Is there? I don't think there cannot be any interim order in
No,
this
Your
kind of things, except for saying that you see, like the court should not proceed any further without and like without any decision being made in this matter. But then, if the pendency of this matter is disturbing the proceeding of the trial, then see, granting time becomes difficult. That is what
Let it come after 1 week, Your Lordship.
it should take these things. Because for this kind of things, for a decision on 311, the matter should not, the trial should not get stalled.
Yes, Your Lordship.
This is now petitioner prays for. The prayer has been made under the petitioner to adjourn the matter by 2 weeks. The state respondent has no objection. Prayer allowed, list after 2 weeks. You just take the latest thing.
Yes, Your Lordship. Obliged, Your Lordship.
Highly obliged, Your Lordship.
Item 1 of the supplementary list, my lord. Regretfully, my lord, even though it's fixed, it was fixed as a fixed item today, my lord. We had prepared the matter yesterday. Mr. Paul had prepared the matter yesterday, my lord. In fact, he was in court in the morning today. He was not well, so he
is
had
not
to
well.
leave. My lord, he was here.
So other day somebody said that his at home his mother was not well. I don't
No,
know.
no. Today, my lord. Yesterday, in fact, he was unwell. Till yesterday, he was unwell. Today, he came. But he again felt uneasiness. So,
See, Mr. Thapa,
my lord.
this matter on the earlier occasion it was adjourned on the ground that there is a talk of compromise.
Absolutely, my lord.
Now, what Mr. Lindo has submitted, that he has never been contacted by me.
No,
So that submission apparently was not correct.
no, no, my lord. That is something that is within my knowledge, my lord. Of course, the client
See,
have
your
approached them or
knowledge-
not is, my lord. That's why I
Your
prayed, my
knowledge is
lord.
on the basis of the instruction. Is
Yes,
It means your client is not giving you the correct.
my lord, my lord. The client had told me that he is basically looking for some kind of a settlement, and to that effect, he's
See, to look for a settlement and to say that there is
he's trying to reach out to a people who are responsible for the settlement,
No,
who
you have
can
not
make
made
out
any
a
effort.
settlement.
There is nothing. No, there is nothing.
That's why, my lord, in the first place,
That is the apparent. You see, like just to buy time, you see those kind of things are made. So this is what is not. This court doesn't appreciate.
I bow down, my lord.
See, that is something.
My lord, I have to go by her instruction, his instruction, my lord, and what I submitted before this honorable court was purely on what instruction I had received.
So then we'll record that your conduct is not good. Then your client's conduct is not good. Then we'll just say.
Well, that is why I prayed, my lord, on the last occasion, my lord, it may not be recorded. My lord, as of now, I am not contacting him any further, my lord, to understand what is the stage of compromise. My lord, I'm making it very clear, my lord, we'll proceed with the matter on merits. My lord, we kindly have this matter on Tuesday or Wednesday, subject to your lordship convenience. Today, my lord, in fact, Mr. Paul had sat down with the file yesterday. I was there to brief him. But suddenly he fell ill again, he had to leave for the house. We can have it on, not Monday, my lord, Tuesday we can have it. So finally, let there be a observation, my lord, no further adjournment from either side.
Tuesday 17.
Tuesday is 17.
Okay, holiday chances no. 16.
Mr. Khan, the difficulty is that the personal, see, like you say, counsel is not well. Now that is one thing you say like.
But if that is a submission, normally we don't object.
We'll have it on Tuesday.
Subject to whether it is a holiday.
No difficulty, Lordship. But Lordship, as on the last occasion, as on the last date fixed, there has been extensive hearing on my end, Lordship. There has been
that has gone out of the mind now. Then again, there has to be an extensive hearing.
The Lordship, the court has been so lenient with the adjournment spread and the continuance spread. Lordship, my humble praise that let the matter be taken up possibly and no adjournment should be taken.
Now, if you say that, and if next day again a prayer for adjournment comes on the ground of illness,
yes, I understand.
Will it be proper for the court to ignore that, especially when that the ground is the lawyer's ill health? Just tell us from the bar. Now it is today is his turn, tomorrow it will be your turn. Yes. So that is what you should think it from this thing as one, not as a
yes
things. When these adjournments are prayed on the ground of the personal difficulty of lawyers.
Lordship, what basically my friend wanted to convey, perhaps he could not.
Now this court was on the other side for 3 decades.
Lordship, on a lighter note, what my friend wants to convey.
Any adjournment, prayer of adjournment is made on the ground of personal difficulty of lawyers, this could definitely not like to reject it unless somebody is speaking like.
Lordship, if I may say lightly, what my friend wants to convey is that he's a bit heartbroken and disappointed when the submission was made today that he bowed down. When it came from the court, that incorrect statement was made, and he bowed down. That means he admits. No. If he admits that the false statement was made, so my friend is only objecting that had it been the case of medical ground, I don't think so. He's going to oppose other.
No, that is normally
for a more than a month in the middle of a hearing, an issue came up when the court asked him, "Do you have a record?" And he produced a record that was given more than a year back in an affidavit, and they took time to read that affidavit for more than 2 months. In the middle of reading the affidavit for 2 months, and then the day came, they said matter is under compromise. That turned out to be a false statement.
No, and I take serious exception to this.
Incorrect statement.
There's no reason why I would make a false statement before the honorable court.
Incorrect statement.
Mr. Allegation is not against you.
No, not against him.
No,
not against him.
You are
not the speaker. You are the loudspeaker.
No,
somebody else is.
My lord, but it falls partly on me as well.
And Lordship, he bows down. He admits it. I don't understand. So my only objection my friend is making is this: in the middle of the hearing, when the matter was about to be posted for judgment.
Mr. Thapa, this falsity should be avoided.
And Lordship will kindly appreciate.
This court.
My lord, to be very vivid and clear, my lord, what the client told me was that he would try to reach out to somebody so that a matter can be compromised.
Supposing now, so not on the other day, it was made clear by Mr. Lindo that nobody had
Approved.
Yes.
That is why,
Was
that
it
is
not
something I
proper-
need to.
Was it not proper on your part
Yes.
after that you call your client and you tell him that you are passing
No,
on bond?
after, my lord,
See, you still decide to represent him in spite of the fact that he gives you misleading
no,
instruction,
why
wrong
I
instructions.
no, my lord. What
Is
basically?
it proper for a counsel to do it?
No, I don't think, my lord. The client
you have
actually.
certain ethics so far as
No, absolutely, my lord. Absolutely. No, my lord. So far as the client are concerned, my lord, what if I have understood him correctly, he wanted to reach out somebody in the government, my lord. That is off the record. So that some kind of a settlement could be made because after all, it's a government land.
Now, Your Lordship, the ball has been shifted from
No, no,
him to
we
government.
never said, my lord, in the first place that we are talking to the private respondent. We never said that.
Government at present is Mr. Khan, no one else. Now the matter has gone out of their hand. It is here now.
Absolutely. Really, what is disturbing, Your Lordship? All said and done, I am fully with him. I am not opposing it. All said and done, a very important point when the court expresses its mind that you don't have an enforceable right, and the matter is very simple. And we had a lengthy hearing for more than 3 months, Your Lordship. Your Lordship will kindly appreciate. A point came when then the Lordship gave them time, and we never objected. More than 2 months have gone. Only at that
We
expense.
can understand Mr. Khan, but then you see that before this court, basically sometimes you see like the situation becomes such, it becomes proper for the courts to make some observation. You see in these kind of things, where you see like the submissions made are apparently false.
I'll leave it to the court. I'm not saying anything.
This should be the last thing to do. You see, like normally in a court proceeding,
No,
because
I don't want to
That's
see
why, my lord,
anything.
this will carry a stigma on the person against whom that observation is. That is what is.
And frankly speaking, Your Lordship, the other day even in the
Let
honor,
us see. We'll just post it on my Tuesday. Let us see what happens on this.
no, whatever instruction they have gone, we never objected. Only
Today,
thing
time has
is,
been short on the ground of health of Mr.
in health ground, there's no issue.
Somebody is not well, then definitely. We just say today as requested for the tribunal list this matter on 17th. Yes.
See,
Alright.
my friend is saying 17 could be a holiday, Your Lordship, and then
What
18.
for? 18th is a holiday. 17th
18th is
not
a
a
holiday.
18th is a
The
holiday.
notification, my lord, is for 18th, Unitarian Day.
Definitely, it is already there. For High
Already
Court, it
there,
is
yes.
already notified.
Right.
The
17
notification
for
which you are
reason we
talking
don't
about,
know.
it is for the establishment of East Khasi.
Correct. Or something. All right.
Daily causeless, item number 1.
But this matter relates to the land acquisition matter, where in some of the miscase, Lordship has passed the order and staying the eviction drive initiative.
Have you corrected the cost title?
Yes, we have corrected.
Yes.
We have corrected. Now, only 46 of them are remain. Out of 90, 46, only 46 of them are remain as a writ petitioner.
Yes.
Now, my lord, the core issue here in this case is, my lord, whether non-compliance of Section 15 of the Land Acquisition Act,
Of the old act or the new?
of the new act, will be fatal to the, my lord, land acquisition process that is going on. That is the main issue. My lord, other prayers also made, but that is the foundation
Your
of
challenge is to the acquisition proceeding.
yes, acquisition proceedings. Acquisition.
Now, at the time when you filed this application, there was an interim prayer
Yes.
to stay the proceeding.
Right.
Now, which was not granted.
Right.
The matter has proceeded as such. Have you challenged that order before any other higher
No.
authority?
I will satisfy, but Lordship, I may please that the order, nature of the order, man. 2 orders are there. One is the order passed in the.
What is your nature of grievance? Your land is included.
My land is, my lord, acquired, taken away. They acquired by the sought to be acquired by the respondent. Ignoring the larger chunk of my land is treated as a RO. Right.
You have a remedy available under there.
My lord, that is not the case. But I'm not canvassing, my lord, to decide whether this part of my land is ROW or not. My basic grievance is, my lord, the collector has every right to proceed with the land acquisition. but he has to fulfill the procedure provided under the Act. Now, if the procedure is not fulfilled, or we can say that right to be heard is not given, then, my lord, the law is very clear, Lordship is aware, Lordship has every right to strike down the land acquisition process. I will cite some authorities to that point. That is the crux of the matter. Why this grievance arises? According to the petitioner, the land claimed by the respondents called as a ROW. According to me, it is not ROW. According to them, it is a ROW. That cannot be decided by this order of court. But that requires to be, my lord, addressed to be heard by the collector. Now, that is the grievance of the landowner. Now, collector duty is to hear them. And collector has no power to reject that one. Under section 15, my lord, collector can hear us, collector can maintain the records and prepare a report along with his recommendation and place before the government. Government can examine himself. The recommendation of the collector is not binding to the government also. Under section 15, government can take a final decision. And once government satisfies itself, and the government can issue section 19.
Now, see this proceeding as the situation as it stands today. The land acquisition has proceeded.
Proceeded, I'll show.
This land has been taken over?
Not yet.
By the acquiring department? Or by the department on whose behalf the acquisition was made? Yes. Now there is a change of situation.
Well,
now any interference at this stage with the acquisition proceeding,
well, that is
what would be the consequence?
My lord, that issue, my lord, is because the section 11 and section 19 declaration was not stated by this order of court, and the respondent proceed. Now, after section 19, what is the procedure? Now, the procedure is very clear. This order of court will never endorse the respondent that you go ahead and do whatever you like. We are not staying the section 19 declaration at this stage. However, if you proceed, maintain the records. They have to, my lord, respondent has.
You have no problem with that order because this order is this thing. So you have to. You are bound by that. You have not challenged this order.
But that was a balance order. That you proceed if you want to proceed, you proceed, but you maintain the records. Now the maintenance of record comes. Maintenance of the record by the collector comes when he followed the procedure. Now after section 19, Lordship is very much aware. What is the next procedure? Collector has to follow. Collector has to issue a notice to the interested person under section 21, which is mandatory provision. He has to hear them. And thereafter, my lord, he can pass the award. And now I will place an authority without hearing, without giving a notice, section 19. I'm sorry, section 21. Collector passes an order, the award order, that is not sustainable. Now, collector overcome that procedure also. What is the next procedure? Collector has to pass the award and issue award notices, so that the landowner will come forward. Either he or she is satisfied with the amount. But if he's not satisfied,
see, like so far as any grievance,
yes,
relating to the award, whether it is in relation to the rate or in relation to the apportionment, measurement, the claim that you say, yes, like I have been left out, everything is covered by the provisions of the land acquisition. Now the situation as it stands today, you can raise only grievance with relation to that.
No.
So far as your challenge to the acquisition proceeding concerned, that doesn't remain in view of the interim order passed by this court.
My respective submission, my lord, if the collector issue section 21 notices, he heard all the parties, and the landowner has a grievance with the quantum of the compensation, apportionment, measurement, or rehabilitation. The provision is there. They can resort for under section 64 for reference and other. But here, my lord, collector did not resort to this. Collector did not follow that one from 2021. He keep it. And suddenly, when Lordship entering in the merits of the matter hearing at the admission stage, suddenly he woke up and he issued an eviction order. And petitioner rushed before this court. Lordship is kind enough to grant the protection. There is no evidence to show that collector has issued Section 21 to the individuals. He has heard the matter. There is no evidence to show that he passed the award after hearing the parties under Section 21. There is no evidence to show.
Is it your case that your name is not included in the list of beneficiaries or the list of?
No. But in the Section 11 and Section 19, our names are there.
So your name is there. Even in the award?
Yes. As
the
a
award
landowner.
also your name is there.
Award, my lord, they are not passing. They are not disclosing any award.
The award has not been passed. There is no award in this matter.
They cannot pass an order.
As far as several landowners are concerned.
No, but then how come submission was made that some people have accepted money and all?
Yes, they have already accepted.
That is the advance there. That is the initial. What about the final?
This is coming up today for the first time. That award has not been done. This was not the issue in the writ petition.
No, but then you see, like whether there exists an award or not, this will have a huge bearing in the matter.
I'll take instructions today, sir.
Because if there is an award and if then their name figures there as the beneficiaries there, the things will go in the other way. But you see, like if you read it together with the interim order passed,
yes,
where is the interim order said that only the record should be kept? So that interim order, you see, like in respect of the acquisition proceeding, the challenge to the acquisition consent has to some extent, you can say that it has a finality in it.
Yes, sir. And that was not challenged.
Once that was not challenged. So that is that.
It was only in respect of structures
So,
and trees.
so their apparent view of this court is that the option to challenge the acquisition proceeding is no more available in the petition. However, but then they have a right to dispute the rate or the measurement or the apportionment or whatever it is.
That is open to them.
That is open to that. Now then the award becomes, the passing of the award becomes a vital question here. Yes, Dr. Mojiga, you are the paying department, are you?
In fact,
we
we filed a missed case. We have annexed the document which has been supplied to us by Collector my lord, that a list of 49 petitioners who have received the amount, my lord, 41 who have not received the amount, and these are the total number of petitioners.
All the petitioners' names are there in your list of beneficiaries. Now, only thing is that what this court is interested to know about the award, final award.
Final award, the state will be able to give, but the list which the state is given to us, my lord.
None of the parties are aware of the fact whether there is exist a award or not. Exist an award or not.
Phases. This relates to Megombre Akhi. For that one particular stretch, there's a lot of disturbance. As far as other stretches are concerned, there's not much disturbance.
Okay, but then this acquisition proceeding was initiated by different notifications.
One single
Same.
One notification. Disturbance was caused in respect of one particular stretch in one Akhi.
The present one.
Yes, there are about the set of petitioners belong to two.
No, but then if the award comes, that will take into consideration this part also, the disturbed part also, isn't it?
Yes, absolutely.
So that is what this final award then becomes a vital thing here.
Normal 49 have received a compensation. They were originally petitioners. They have withdrawn from the case. Their name have been struck out.
Yes.
So 40 of the remaining 41 whose names are there are also similarly situated. But they cannot be differently situated than those 49.
They were similarly situated at the time of filing. Now they are no more similarly situated.
No, but the only difference is that they have not received the compensation. But their names are there, amounts are specified.
No, but then until and unless a final award is there, how can we come to the conclusion that their name is there?
Well, the chart which is available here.
That is with regard to the initial payment. You see, if there is no award, how can we make a final payment?
Well, the award must be there because the date, the payment was done in the year some 21, 22, 23 till 24
So
months.
I think the initial there is a provision, isn't it, that you have to pay a certain percentage and all. Is there any something like that?
That is what they are claiming. You go by the record. There was no final award. So what is
Lordship, we just actually this morning itself I was trying to get in touch with the deputy commissioner. He's not reachable. Lordship, give me 10 minutes. I'll just come back with the information.
That is okay, but then
as
if
far
the
as the award is
but
concerned,
then
there's a specific publication of the award.
no, but then if there is award, then we must know whether the names are there or not.
Yes.
How can you telephonically confirm that?
They have the name. They have the entire list. This is almost debated.
Telephonically you can confirm it.
Yes, sir.
There
We
are
have the entire
there are
information.
40 some
They've already given us a list of people who are who have accepted the compensation, who have not accepted the compensation. Presupposing that the names are already there in the final list.
and you can pass on the court the details of the award.
Yes,
Will
sir.
be
I'll
possible.
just take instruction. Just give me 10 minutes.
It's okay. It is not only your yes or no. It is also that if you get this thing, because this will be made a part of record, which this has to be reflected in the order.
Yes.
So that is why you will be needing details of that. But if you can do it in 10 minutes, that's fine.
I may proceed. In the meantime, he can take instruction.
That is because if you see your barbell thing, and if you say that we can move on the basis of your barbell submission, that also we can do. But then that there the risk will be there with you.
Because we've been trying to get in touch with the DC, for some reason his phone is switched off.
No, then you do one thing, Mr. Sen. You obtain these things. I think since there is an already passed in these matters, the situation will not change within 1 week. So you can have 1 week's time and take instruction. I think that is better.
Lordship will happen on Monday then, instead of 1 week.
Monday there is uncertain this court whether it will be here or not. So there is some uncertainty.
As per Lordship's will.
Or no, it's not. Then we can have it on
Tuesday, 17th.
17th. There will be many matters.
I have also some few parted matters on Tuesday.
17th, I think there will be
19th.
Just let us verify the situation. It can be on 19th also, isn't it?
19th.
If subject to Lordship convenient 20, 19, I have some
See,
matter in
Mr.
court.
Sanglesha, this is
Only one thing.
of you people. You see, like normally this court should be here, except for the purpose of, you see, like sitting in division bench. We do not know how long division bench takes. Depends upon the length of the division bench. Otherwise, this court is there here.
My bad. 20 subject. So I have some matter in court. Yeah.
19, 20, both are 19. There is some urgency as far as we are concerned in this case.
Now you have urgency. All along, Dr. Mojika had urgency.
We've always had urgency.
When Dr. Mojika was having urgency, you were silent. You are sitting cool and calm.
You were supporting them.
No, urgency.
Malad, only one thing. An HIDCL statement came out in Ceylon Times, Malad, sometime. One statement came out in Ceylon Times.
Difficulty on 19th.
But 19, I have some matter in Guwahati. So 20, if Lordship.
Let us try it on 17th then.
17.
17.
List this matter. Hard learning counsel for the parties. List this matter on 17th. To enable the learned senior G, also learned GA. You are no more senior GA, learned GA. To obtain instruction. Obtain instruction as to the latest position of the acquisition proceeding. Up to the latest with regard to the status, on regards to the status of the latest status of the acquisition proceeding of the matter. Okay, but just correct it. Just what's here.
Well, may I pray, my Lord, interim order passed in this case number 136.
Yes.
139 may be continued till then.
So, in the meanwhile,
As modified. That was modified on the last.
What did order dated? Just give us the date. The last modified date.
That is, my Lord, the last week.
2/9, 2nd September, is it? Yes. Yes. In the meanwhile, interim order dated 2/9/2024 passed in case number
136 of 2024 and 1339 of 2024 shall continue. Well. Okay. So in the miscases, just say list on everywhere, just list on. You don't have to say any other thing to enable list. Only the list on. Yes. List on 17th. 17th. Obliged.
Hearing item number 3.
Yes.
Your Lordship, if I may, the conducting counsel is out of station.
Who is conducting counsel?
Mr. SD.
He is. Which district counsel is a party here?
Yes, Your Lordship.
Yes. Who is appearing for the private respondent?
It's Sir Pinongbri.
This is item number?
Item number 3. Your
That has not been mentioned. No mention. Yes. What is your prayer? Yes. What is your prayer? What do you want now?
Your Lordship, let it come after a week.
No objection.
A prayer for adjournment has been made on behalf of the respondent number
1, 2,
1,
and
2, and 3. On the ground of on the ground that conducting counsel is unavailable. You are appearing for, madam?
Number 4, Your Lordship.
The learned counsel for the petitioner has no objection. They are allowed list after?
A week, Your Lordship.
After 1 week?
Yes, Your Lordship.
That is all right for you? List after 1 week.
Much obliged, Your Lordship.
Item number 13.